Welcome to the Monday, July 23rd meeting of the Mayor and City Council of Atlanta. I would like to invite Ms. Kapork to come forward and lead us in the pledge. Would all stand and face the flag? Roswell. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Cameron, would you like to come to the microphone and introduce your brother and sister and your, I believe that would be your mother with you? The microphone's right up there.
Mr. Mayor, I gave you incorrect information. Aria is her friend.
Okay.
This is my friend Aria, and this is my brother Ryan. You can't really see him. My name is Cameron.
And who else is with you here tonight?
My mother.
And her name is?
Amy.
Good to have you here at City Council meeting. We'll be calling your agenda items soon. Do we have a motion to approve the consent agenda? Motion by Councilmember Price. Is there a second? Second by Councilmember Wynn. Does anyone in the audience have any questions regarding the consent agenda? All in favor of the motion, raise their hands. Passes this unanimously. At this time, I'll call Councilmember Eichelhardt.
Thank you, Mr. Mayor.
Discuss the resolution.
As we've just heard from our Pledge of Allegiance, we have a special guest with us tonight and a special resolution to encourage the education of citizens on the harm done to the environment by balloon releases. And our rising third grader, Cameron Kapork, who just met, the rising third grader at Sweet Apple Elementary, and she's been active here at the city and with Environmental Public Works all year. Because earlier this year, she took part in the Drippy Dropperson comic book contest, and so she was part of that, and we got to see her earlier this year. And then, along with that, she has been talking with Stu and different members of our staff, including Vicki, who we should also welcome back with us today, and about this balloon release and what problems it causes for the environment. Well, as it turns out, our ordinances already cover that, but we thought that was a very good idea from both the department and Keep Roswell Beautiful to come forward with this resolution as an education standpoint. So I want to bring forward, would it be Stu, Vicki, everybody?
Before we hear from them, let's hear from our citizen as to the grounds for this resolution. If you'll come to the microphone. Cameron.
Thank you for inviting me here tonight and for addressing my concern about balloons and the environment. To quote one of my favorite movies, The Lorax, unless someone like you cares a whole awful lot, nothing is going to get better. It's not. Together we can make a difference and keep Roswell green.
And if you could educate the council and the audience as to the harm that releasing balloons causes.
Sea animals and other animals like birds can choke on balloons and die.
And it also creates litter in the community. I know in my woods from now and then I'll see a balloon, and it's litter like any other trash. Mm. Well, thank you for bringing it to our attention, and I'll turn it back to Councilmember Eichelhardt.
Mr. Mooring and Colbert today.
Yes, sir. Thank you. Well, Cameron brought this issue to our attention, and she has been working with Vicki Colbert, our environmental education coordinator, and helped us to develop this resolution because oftentimes we find that people are not polluting out of some disregard, but basically out of ignorance. They just don't realize that there is an impact to things that we do on an everyday basis. So Cameron has brought this information to us. Our existing ordinances help us to control that, but what we are interested in and that Vicki will be working on is an educational program to help people understand the impacts that Cameron has brought to our attention. So, as we have often stated, the great thing about being in Roswell is that we have citizens who are concerned, who want to make this a better place, and that's reflected by the caring attitude of our mayor and council. And so, from the staff and from Cameron, thank you very much.
Mr. Davidson, would you read the proposed resolution?
Yes, thank you, Mayor. This is a resolution to encourage the education of citizens on the harm done to the environment by balloon releases and to find an alternative way to celebrate special occasions. Whereas the City of Roswell promotes a clean and healthy environment through partnership with Keep Roswell Beautiful, and whereas Keep Roswell Beautiful's mission is to educate, motivate, and empower the citizens and businesses of Roswell in the beautification, conservation, and preservation of our environment. And whereas both the City of Roswell and Keep Roswell Beautiful recognize that litter comes in many forms, including balloons, and whereas there are alternatives to releasing balloons during celebrations, such as bubbles or a balloon drop, and whereas Roswell resident Cameron Kapoor, a rising third grader at Sweet Apple Elementary School, brought this concern to the City of Roswell's and Keep Roswell Beautiful's attention, now therefore be resolved by the Mayor and Council of the City of Roswell that the citizens, schools, and businesses in Roswell are encouraged to educate themselves on the harm done by balloon releases and to find an alternative way to celebrate special occasions. It would approve this to be the reading of the resolution.
Do we have a motion?
It's my honor to move for approval of this resolution.
Motion by Councilmember Eichelhart. Is there a second? Second by Councilmember Diamond and Price. All in favor of the motion, raise their hands. Passes unanimously. Councilmember Orleans is absent with an excuse. If you will pass along a copy of that resolution before you leave tonight, we can give you a copy. So, Kay, do you have a copy? Mr. Davidson? If you'll pass it down, we'll get a copy to you. Absolutely, we want a signed copy of that resolution. And it's our pleasure to sign that, and you can take this to your class and say you are already making a difference in your community, and we appreciate it. And with that, I'll call upon get back to the regular agenda. Oh, pictures. Absolutely, we want pictures. If the council will join the Camden, we'll get some photographs taken. But first of all, let's get this signed.
Thank you, Mr. Mayor. This item is approval of a resolution to authorize a master lease agreement with the Georgia Municipal Association and approval of the Georgia Municipal Lease and addendum for the purchase of fire apparatus in the amount of $1,650,000. Mr. Lee.
Thank you, Councilmember DiPolito. Tonight I have before you a request to sign a GMA master lease, Georgia Municipal Association, with the City of Roswell. This lease is for $1,650,000. It includes the purchase of one fire engine for $450,000, one ladder for $1,200,000. The total annual payment for this lease is $181,160.03. It's at a quoted rate of 2.14% with a 10-year term. Correct. Yes, sir, it is.
Please turn
Yes,
on
sir.
the microphone.
Let's start over again. And I apologize. When you mentioned the rate of 2.14% interest, is that the effective rate of interest that we're paying over and above the purchase price of this equipment?
Yes, sir, it is.
And that's 2.14% a year?
A year, yes, sir.
And are you recommending that as a wise financial move?
Yes, sir, I am.
Thank you. Does the council have any other questions? Councilmember Price.
There's something in these in the paperwork that talks about accepting the fire truck as is, but it is they are new vehicles, are they not?
Yes, ma'am, they will be new vehicles.
Brand new, never used.
Never used, yes, ma'am.
Great, thank you.
Now, is this a replacement of an old truck?
Yes, sir, it is, I believe.
And how old is that truck?
Mr. Mayor, the replacement for the fire engine is for a 1991 model, and the ladder truck is a 1986.
So people want to understand we take good care of our vehicles and we get all the miles out of them you can reasonably expect. And
We certainly do.
There is a good reason to replace these vehicles.
Yes, sir.
Thank you, sir.
Thank you.
Any other questions? Councilmember DiPolito.
Thank you, Mr. Lee. I see the lease is for 10 years, and we have the opportunity to purchase the vehicle for $1 at the end of the lease,
Yes, sir, that's correct.
and we intend to do that.
That would be our recommendation, yes,
And
sir.
there'd be no lease for the remaining 10 years that we will use it after that.
Yes, sir.
Thank you.
Any other questions? Councilmember Price.
On page Exhibit B, there's there were alternative payment schemes, and it's my understanding that we're going to do this annually. Is there any merit to doing it in another fashion?
No, ma'am, we would pay it annually as is the most efficient way from an accounts payable standpoint to produce or dispose of the payments.
I mean, if we did it semi-annually, that wouldn't reduce the interest on it?
No, ma'am.
Kay Love would like to speak to that point.
Councilmember Price, mainly the options are there for governments who have a cash flow problem that requires them basically to borrow the money in the first place. So this rate is annualized, so it doesn't make a difference in the amount of money that we pay, whether we pay it monthly, quarterly, or annually. Thank you.
Any other questions? Do we have a motion?
Move to approve.
Motion by Councilmember DiPolito to approve the lease. Is there a second? Second. Second by Councilmember Wynn. Does anyone in the audience have any questions or comments? All in favor of the motion, raise their hands. Passes unanimously.
Thank you.
This time we'll call upon Councilmember Nancy Diamond, Liaison to Community Development Department.
Thank you, Mr. Mayor. This is approval of an amendment to Chapter 14, Parks, Recreation, and Cultural Affairs, and Chapter 15, Reserved of the City of Roswell Code of Ordinances. This is the first reading, and Ms. Alice Wakefield is here.
Thank you. This is a request to approve an amendment to the Code of Ordinance by removing the section dealing with special events from Chapter 14, which is the Parks and Recreation section, and moving it to an entirely new chapter, Chapter 15, which would be special events, filming, and public use of city facilities. This ordinance will clarify the special event process. It gives the defined definition of what a special event is, what activities that are exempt from this provision of this ordinance, the application deadlines and the contents, standards for denial of a permit. The most significant thing about this ordinance is that it established the process and the procedures related to applications for sponsorship of city resources in conjunction with the special events. And this will function much, if approved, like a grant process where twice a year Mayor and City Council will approve those special events that are seeking sponsorship from the city. This is the first read. We're asking you for approval. We will come back at a later date to bring forth the provisions of the ordinance dealing with filming and public use of city facilities.
Are we anticipating the people who have in the past who applied for special events to see any significant change in what's granted?
No, sir.
But it makes it clear what the grounds are.
Yes, sir. It makes it very clear.
So if you have applied for a special event in the past and it has been granted, you shouldn't have any trouble working through this?
No, sir. In fact, if once this is approved, we're going to send out detailed letters to the applicants that have applied previously, explaining the process, and we're also going to schedule a meeting to again explain the new process and to answer any questions.
But if you currently have an event approved, you're already approved.
That's correct.
It does not. Application.
It's a new application.
And when will this? For what period of time are we proposing this to be effective?
If this is approved on the second read, which will be in August, it will impact. The deadline will be September the 30th for those events that occur from January through June of the following year.
And we are sending out notice to all of the previous applicants that they now have a deadline.
Yes, sir.
Other questions of council? Councilmember Price.
In section 15.1.9, B number 8, it references one of the criteria for which sponsorship would be granted is if the entity is a nonprofit and at least 50% of the proceeds go to a nonprofit. First of all, I'm trying to imagine a scenario where a sponsorship would be granted if it were not a nonprofit. Is there such thing?
There have been sponsorships granted to some events that weren't purely nonprofit. I'm not sure if the criterion is a purely nonprofit event, for example. So there have been incidents where the city, for economic development reasons, the benefit to the economic development, have granted sponsorship. This is just one of the criteria that applicant could provide.
I guess that was my first question. Was sort of I couldn't imagine a situation where it wouldn't be a nonprofit, but then the second half of that proviso is 50% of the proceeds going to a nonprofit. I don't know how we would. Are we asking to see their books, or how would we know where the proceeds of their event go?
Well, basically, we're going on the honor system, and as part of their application, this is one of the questions. Basically, they will be asked to provide the information. And so we will take them at their words that their fundraiser is to benefit the nonprofit.
I'm just wondering, and I know we've talked about this at committee, but if we were to look at their total proceeds and as a percent of what they raised or made at that event, this really is talking about what we would charge them, I suppose, more than anything else, or what we would grant them more than anything else. But still, I'm just not sure that whether or not, I mean, if they're a nonprofit, I mean, the presumption is that it's going to the nonprofit. So you're just saying you ask the question, and then if they say yes, I mean, I can't imagine them saying no.
Can't imagine.
So if they say yes, then that's just one of our criteria.
Yes,
criteria.
Sir.
All right.
And we can go back and look at that provision.
Okay, thank you.
Any other questions? Do we have a motion?
Move to approve first reading.
Well, let's read it
Sorry.
first.
Thank you. This is an ordinance to amend the Code of Ordinances of the City of Roswell, Chapter 3, Alcoholic Beverages regarding special events. Actually, it's Chapter 15, special events. Sorry. Now, therefore, be it ordained, and it is hereby ordained, that Chapter 14, Parks and Recreation and Cultural Affairs, and Chapter 15, Reserved, of the Code of Ordinances of the City of Roswell is amended as follows. The Roswell Code of Ordinances is hereby amended by deleting Section 14.3, Special Events, and establishing a new Chapter 15, Special Events, Filming, and Public Use of City Facilities, including Section 15.1, Special Events, to read as follows. Text of which is incorporated herein by reference, and if approved, this will be the first reading.
Do we have a motion?
Move to approve first reading.
Motion by Nancy Diamond to approve the first reading. Is there a second? Second by Councilmember DiPolito. Does anyone in the audience have any questions or comments? Any further discussion by council? Councilmember Price.
One question in section 15.1.16, the appeal procedure. I guess the only thing I can imagine there is that possibly if somebody missed one of those deadlines or what have you, that perhaps an application would not even be accepted, therefore it couldn't be denied. So I'm wondering if we could add something in there to say any applicant whose special permit application has not been accepted or has been denied or revoked, just in the situation that there's some extenuating circumstance that they missed a deadline, and even if it had not been denied, at least we could go through some sort of appeal process.
Yes, ma'am.
So is that an amendment?
Yes, I'd like to make a motion to amend section 15.1.16 to add in the first line, any applicant whose special event permit application has not been accepted, comma, denied or revoked, etc.
Is there a second? Yes.
I'm a little confused about the wording. What exactly are we trying to accomplish?
I think it's a clarification so that if an application is rejected, Councilmember Price wants to make sure that's treated as a denial.
But if you say it has not been accepted, even if they don't make application, they would qualify for appeal.
No, they would have to apply. And I think the concern is that if it's not if the application is rejected as late, it's not treated as a denial but a rejection. I think it's just a clarification. So that if the intent would be that if for whatever, whether it was denied or rejected, you could appeal. Councilmember Nguyen.
Ms. Wakefield.
Mm-hmm.
Denial and missing the deadline, is that two different animals? I mean, if somebody misses the deadline, do you even look at the application at all if they've missed the deadline?
No.
So that's not a denial?
It's
just that they did not?
Yes.
Okay.
They missed the deadline.
They missed the deadline. So that is not a denial or a revocation of the application. It is that you don't even look at the application at all. Am I correct?
That's correct.
Well, then I can't go with the amendment.
I support the amendment because I think under extenuating circumstances it might be appropriate, even if it's late, to consider it.
Well, then I would suggest that we put in a timeline because I don't want somebody coming in a week after the deadline saying, "Oh, I'm sorry, but I missed it." I mean, this is opening up a whole new gamut here, and I don't want somebody coming in a week or 10 days or 2 weeks later say, "Well, I didn't know that there was a deadline," and now we have to start this process. So if you're going to put that in there, I think there should be some type of a timeline. If it's 48 hours or 72 hours, I don't care, but I don't want this open-ended on that. I can't vote for something that's open-ended.
I can support it's open-ended because the council would make the final determination as to whether or not to grant it. Councilmember Diamond.
I guess I just have a concern that it might be a way to bypass the process. I mean, if you don't want to go through the whole vetting process, you just appeal it late in the game and go directly to us. And I mean, there must be a middle ground there. There must be another way to do it.
Well, I support it because there are many circumstances under which the applicant would have to justify to you a good grounds for denial. And given the nonprofit world, we have a lot of good causes that I would support otherwise, and because they missed a deadline which they didn't know about, or somebody got sick, or somebody left town, it is a voluntary organization, and I'd like to see the council to have the latitude to grant something in the event of extraordinary circumstances.
And I don't disagree with that. I guess I just would like maybe not the deadline to be a part of it. I would like it not to be an open door to just bypass the process. There must be some.
Well, what if
wording
we
that
said
can make
this?
that work.
What if we said that they would have to show extraordinary circumstances or something to that? Mr. Davidson could probably come up with some language rather than just say, "I'm just late. I want to get it." You'd have to show something to justify that they missed it.
Maybe by second reading we can have something on that front.
And so, therefore, I think it wouldn't be just, well, I just didn't feel like it. That's not extraordinary circumstances. But Mr. Davidson, I'm sure, can come up with some language. As lawyers, we know all about deadlines and extraordinary circumstances, and there are rules that apply. It's not enough to say, well, I just wasn't ready. So we'll work on that. That amendment fails for lack of a second, but it's a suggestion before the next reading, and we'll consider it then. Councilmember Price.
Well, the fact that we're already in this section going to grant the ability to appeal based on a denial or a revocation, which presumably would be for cause, then for somebody who just missed the deadline, for instance, we're imposing new deadlines now with this March 31st deadline for any event July through December, and also the September deadline for any events for January through June of the following year. And I anticipate that in the first year of this, there will be a number of people who won't know, and we will never know that they were not even rejected because they will just simply not have been accepted. And I think that when people just walk away and think that that's the final answer, that they need to be apprised of the ability to rectify their oversight.
Councilmember Price, you had made a good suggestion, and I anticipate that with Mr. Davidson's additional language to talk about under what circumstances you could appeal, we'll find something that's acceptable to the entire council.
Thank you very much.
So we have a motion to approve the first reading with a suggestion that we consider additional language at the second reading. We have a motion and a second. Does anyone in the audience have any questions or comments? Any further discussion by council? All in favor of the motion, raise their hands. That's unanimous. And now we're on to Councilmember Becky Wynn, Liaison to Public Safety Department.
Thank you, Mr. Mayor. Approval to renew the MOU between the Department of Justice, Drug Enforcement Administration, and the Roswell Police Department. And instead of having our chief tonight, we're going to have Major Watson. So, Major Watson, would you present this to council, please?
Good evening. Thank you. For more than 3 decades, the Drug Enforcement Administration has put together or has called on local and state agencies to develop task forces to combat all sorts of illegal drug activity. And they've been mainly to combat high risk or high activity or high level drug dealers. The city of Roswell has participated in, I think, more than 30 years. We've had an agent or an officer assigned to work with the agency. The current one, the officer that we have now is Officer Dwayne Good, and he's been there for approximately 13 years. This proposal is simply a renewal of that same existing relationship that we've had with this federal government agency.
What's been our experience with on the recoveries on this and the financial impact on the city of Roswell?
You mean expenditures versus
revenues.
I think Keith Lee could probably answer that question better than I. It's been fairly extensive. I really can't tell.
Kay Love, can you answer that question?
Not exactly dollar amounts, but certainly the amount that we pay for the officer and his equipment is much less than what we receive because of the forfeitures gained from the entire task force. We all share equally in those. So we have had as much as $300,000 in 1 year or as little as $50,000. We have had a healthy fund balance accumulated in the confiscated assets fund over the past years and have funded a variety of equipment and needs that the department has had that have not been otherwise funded through the general fund.
So in addition to the public safety benefits, you're recommending this from the financial side?
Yes, sir.
Any questions? Do we have a motion?
Move to approve.
Motion by Councilmember Wynn. Is there a second? Second by Councilmember DiPolito. Does anyone in the audience have any questions or comments? Any further discussion by council? Councilmember Price.
This came up at committee, but I just want to reiterate it here. I'm concerned about the liability of the office of the city for an officer who's under the direct supervision and control of DEA while salary paid by the city of Roswell. And I know there's no language in this agreement that protects the city, but I wish there were.
Well, I think in the committee it was a legal question may have been deferred to Mr. Davidson, but in my research today, I followed up. If you look at item number 4 on the agreement, which reads, the RPD officer assigned to the task force shall be deputized as task force officer of DEA pursuant to 21 U.S. Code 878. And after I looked that up, that deals specifically with the powers of enforcement personnel. And the very last item under 878 is B, state and local law enforcement officers performing functions under this section shall not be deemed federal employees and shall not be subject to provisions of law relating to federal employees, except that such officers shall be subject to Section 3374C of Title V. I further went to that section. And in Section C of 3374 of Title V of the U.S. Code, it says, during the period of assignment, a state local government employee on detail to a federal agency, and I go to item number 2, is deemed an employee of the agency for the purpose of Chapter 73 of this title and several other acts and information, as well as and the Federal Tort Claims Act and other federal tort liability statute. There I defer to Mr. Davidson to cover anything that the Federal Tort Claims Act may address the issues that you raise.
Yeah, it's my opinion that the city has absolutely no liability unless our officer, does something out of character. But for his actions working under the supervision of the DEA, we don't have any liability.
As long as he's following the supervision, we're okay.
Exactly.
If he goes off the reservation and doesn't follow the supervision, we're okay. Any other questions?
If I may add, there's one more section that deals with the individual officer, and I'm not sure if it really answers your question, but I think that somewhere in there would be the answer to as far as the city goes. But in Title 28, Chapter 171, the Federal Tort Claims Act, Section 2679D1 provides that once the Attorney General has certified that the employee, and if you refer back to 3374, our officer is considered a federal employee. If the employee was acting within the scope of employment, the United States will be substituted for the employee as the party defendant in any action filed against the employee. D2 of that same section provides for substitution of the United States in actions filed in state court, and it also provides that the action will be removed to federal court at any time before trial. So it really falls back to what Mr. Davidson is saying, that if he's acting within the scope of law, and that's basically within the rules and regulations, that the federal government will become the party, it will remove the officer from being the party of the lawsuit.
Thank you, sir. Any further discussion? All in favor of the motion, raise their hands. Passes unanimously.
Okay, the next one is approval of a project management proposal from Comdex for the North Fulton Radio System Project, and this was going to be, they're doing tag team tonight, Mr. Mayor. This is Captain Sweeney. We'll be presenting this.
Good evening. As most of you will recall, over the last 2 years, Fulton County has advised us that their plans are to get out of the radio business. Right now, as you recall, all public safety in Roswell is on the Fulton County trunk radio system. Knowing that, the city has, or the police department and the fire department jointly have researched some other options and have led us to a joint North Fulton system with the combined five North Fulton cities working as a group. We've had many meetings. In the process of doing so, we have asked Motorola to give us a quote on projected build-out of the North Fulton system, and we have that. The last meeting that we had between the five groups, 5 cities, with representatives there from both police and fire chiefs, suggested that we do 2 or 3 things. The first of which was that we research forming an authority for governance of the for the 5 North Fulton cities and governance of a North Fulton radio system. We also agreed to hire a consultant to research the contract and a proposal from Motorola for validity, cost effectiveness, and any potential loopholes. The consultants came back and they recommended that one of the biggest loopholes that they could find to hold back a project was the fact that property and tower, lack of better words, the city doesn't have any property right now to put towers on, and what we're looking at is to go out and look at potential points of the city. We had Motorola and the consultants look, and we've identified 2 potential points of possible use. The real issue here from the consultants was the fact that property is, and gaining this property is the biggest number one point of failure and delay in development of a new system. So the 5 cities unanimously voted to hire a consultant, Comdex, which is referred to as Phase 1 in your documentation, to go out and research the potential sites, the potential problems, the potential zoning issues that we'll have in picking up on the new system, and forming a MOU for a joint authority between the 5 cities. That is before you today. That is $8,600, which is considered Phase 1 of Comdex proposal, and that is to draft a government project proposal for an MOU, a draft letter of intent for cities, for an MOU between the 5 cities to act as one, and number one, to do a tower site search and initial negotiations on behalf of the customer, which is the 5 cities, the North Fulton cities. And as you recall, Sandy Springs is the one that's on the last project that actually contracted with Comdex, and the 4 cities had MOU agreements with them to provide that. It will provide the cost estimates for each site, identify any potential zoning problems or permitting problems, recommend alternate sites for the proposed sites for coverage. The key point behind all this is that the county system has known coverage issues. I think Chief Spencer will back me up on this, that we have several major areas in the city that we can't talk very well. It's not considered a 95% coverage as public safety requires. We have asked both Motorola and Comdex to research that we have 95% in-building coverage through the entire city, especially for the firefighters. when they get inside a building and can't converse. They will assist us in any permitting up to a point and create the MOU for the joint authority. There is a phase 2 here, which is optional, which goes into great depth, and it will eventually, by what they put down here, is that it will go all the way through to the inception, completion of the project, and that's all optional. That has nothing to do with phase 1.
A couple of questions.
Yes, sir.
How many tower locations is it anticipated we need in the city of Roswell?
In the city of Roswell, 2. We're proposing a site at Fire Station number 6 on Cox Road and East Roswell Area Park.
So we're hoping that we can put this on city property on those 2 locations?
Yes, sir.
How long do we anticipate before this system will be up and running?
They're saying a 2-year build time from contract. The equipment could be here a little bit faster, but depending on how many towers we build or existing towers that we use, if we use all existing towers, it could go up very fast. If we put up our own towers, it takes 5 to 6 months to put up one site. Of course, they'll be doing multiple sites at the same time.
You mentioned you had a quote or an estimate for the total build out. Do we know what this total overall project
projected is $15 million.
And that will be spread between all the cities?
Yes, Mayor.
Ms. Love, over what period of time are we going to have to come up with, what do we anticipate what our share of that $15 million is going to be and when we're going to have to come up with it?
We have talked about around the $5 million number, but it's all pending on the sites, the locations, all of the licensing and permitting. So that's a very preliminary number at this time. We anticipate funding it over not a 24-month period, but it would run over 2 fiscal years. We have some things in play now that we could be coming forward in FY 2013 and then the balance in 2014, but that's unknown right today.
Do we anticipate we're going to be able to absorb this cost without throwing a big wrench in our budget?
If things work out the way we think they will, yes. However, like I said, it's preliminary, so I would never say never, but what that would mean is that some other projects may get moved down on the priority list as this project moves forward, but we don't know that yet. It's too early. It will be several months before we know that.
Thank you. Other questions of council? Do we have a motion?
Motion to approve.
Motion by Councilmember Wynn to approve an $8,600 contract with Comdex. Is there a second? Second by Councilmember Diamond. Does anyone in the audience have any questions or comments? Any further discussion by council? Yes, Councilmember Bryce.
In the committee, we talked about our share was a lot higher than some of the other cities based on the number of radios that we had. Have we evaluated the number of radios that we have and need?
Yes, ma'am. We're in the process right now. We have 2 weeks left of our final inventory, where we went back and converted all of our old analog radios to digital, which will allow us to move to the new system. In the process of doing that, we identified several radios that were not necessary in our operation. And working with Chief Spencer also, we identified, because we did everything in the city. And in the process of doing that, we realized that he had a radio cache as emergency backups for any disasters or any unforeseens. We had the same cache. So we're eliminating that redundant cache, and we're going to share resources, and that should cut back the radios. The biggest thing with us is that we realize that it's 607 radios that are in the inventory, and if we drop that number, when we start dividing up $15 million, it's going to be significant, so we need to get tight, and that's what we're in the process of doing.
So is this the same number, though, that we had presented at committee based on the old number of radios?
The 607?
Whatever it was, yeah.
Yes.
Because
Yes.
those numbers aren't in this packet. I'm sorry.
I'm sorry. Yes, that is the same number.
So are we going to be able to modify that before this agreement?
No.
So
We'll be able to modify that before the next agreement.
Absolutely.
Good.
When's the next agreement coming?
Depends on what happens out of this one. I can't really say, but
The next one's going to be the big number.
Right.
not the $8,000 number.
Right. This is relatively small. However, we need to ascertain what percentage we are expected to cover relative to the other cities, and if it's based on phase one, then we're kind of up a creek.
It is not based on phase one. When the final contract comes out, we're going to do a total inventory, and I suspect that the other cities, since they're growing, will increase their number, and we're going to go down. I'll make that statement right now. We're going down.
Will you keep us apprised of those numbers?
Yes, ma'am.
Thank you.
Any further discussion before we take a vote? All in favor of the motion, raise their hands. Passes unanimously.
Thank you.
This time we'll call upon, is Kay Love going to call the Recreation Parks, or we have a volunteer?
I'm happy to do it.
All right, Kay, if you'll call that calendar.
Thank you, Mr. Mayor. This item is approval of revisions to the Cultural Arts Center policies and procedures and rules for use. Morgan Timmis is here along with some of the Cultural Arts Board members to present this item.
Good evening, Mayor and Council. These are the revisions which were reviewed in committee. There aren't any changes proposed since the committee vote was taken, and the primary revisions are of substance is to extend the allowable period for renters to the facility to rent the facility out as far as 24 months out. And then there are corresponding penalties for cancellation of those contracts that are varied depending on the period of time in which they cancel. Many of these revisions are virtually typos. There's an addition for a small fee if renters fail to remove property from the stage, and there is a small increase from $25 to $50 for the rental of the concession stand. Change in the language that refers to ticketing, allowing renters to take advantage of our new ticketing system if they so desire. And that's pretty much it.
Does the council have any questions? Councilmember Price.
Now, with respect to, say, a resident company, does this supersede, or can there be contractual arrangements made that are in conflict with this?
No, ma'am. The resident company has its own unique contract, which supersedes this, essentially. All of the user provisions are unique to them within that contract as specified in the contract.
Okay,
and
so this is separate and distinct and may actually be in conflict in some points.
But it's not. We have reviewed it we really only have one resident company now of significance, and we've gone through it with Georgia Ensemble Theater, and nothing that is proposed to change here. They already contract for 2 years out, so it doesn't really affect them.
And I know we talked in committee about the length that we could actually, let's see, where is that? Set up a contract, and I think we extended it from 6 months to 2 years.
That's correct.
And was there any reason we couldn't do it any greater length of time than that? Because I understand that there are some situations where a booking might actually be necessary more than 2 years. Is there any reason we can't do that? I know the mayor had an objection before saying that, well, what if our fees changed? But could we not put language in the agreement that says they would abide by the fees at the time of the event or something like that? If it's felt that we're losing acts because 2 years is not long enough to get them on the books.
That may be possible. The board voted to look at the time frame again in a year from now. One of their concerns was their interest in building the Roswell Presents program and identifying additional dates, and didn't want to get into a position where there were a lot of dates that might be desirable for the Roswell Presents program already taken years out. But We did not go into any real discussion about the possibility of language within these policies that would provide for an opt-out if fees were increased. That's something that could be discussed.
I think it'd be advisable or desirable to have the opportunity to book a really great name if they weren't in the habit of booking inside of 2 or 3 years. I don't know how to make that into the language, but I know there's someone in the audience who would probably like to speak to that as well.
Any other questions? Questions? Any other questions? At this time, I'll recognize anyone in the audience who has any additional comments about this policy changes. Does anyone wish to speak on this? Come forward, please, if you'll give us your name and address.
I'm Nancy Talbert Yolmus, and I live on Lum Crow Road in Roswell. I'm someone in the audience that would like to speak about the length of the contract. It's difficult for us to get guest artists in a 2-year frame. We were hoping for a 4-year frame of window of opportunity for bookings. I realized the cost of living could go up, and so the cost of the theater could go up during that time, and maybe that could be put in the contract that in the event that the cost of the theater goes up, whoever has that date has the option of either keeping that 4-year date that they had booked out or opting out of it. So I'm someone in the audience, and I thank you for your time. And while I have the floor, I'd like to thank Morgan and Jess for all the work they've done on this. We've worked together, and that's the whole game, is to work together. So thank you.
Jess, what is the practice in other facilities? What's sort of commercial practice on reservations?
It depends. It runs the gamut, going from anywhere from 2 years to 7 years to 12 years out. It depends on the different facilities.
What are your thoughts?
I really think that right now we probably should stick with a 24-month as the Cultural Arts Board recommended, simply because we're in the process of starting our own presenting series, and I don't want to get in a position where we're locking ourselves into deciding dates for other groups before the city has a chance to decide what dates they're going to take advantage of in the next couple of years. I do think that we should revisit this probably in the next 12 months, as we'll have a much better idea of how our presenting series is going 12 months from now.
Thank you.
Yep.
Any other questions of council? Councilmember Diamond.
What was the policy before this? 6 months? And did the board...
We're moving in the right direction.
Okay. Did the board look at longer, or this was a big move to go to 24 months?
They did discuss longer, and like we said, that their vote was to go to as far out as 24 months and reconsider again in a year, for all the reasons Jess just explained.
Councilmember Diamond.
I guess, I totally respect the board's decision on how they came to this. I guess my concern is that we're putting the city presenting series ahead of anybody else. I'm not sure I'm comfortable with us being the first in. If there are other entities that want to do that, it seems like there ought to be a level playing field, whatever that timeline is.
We met in June, I believe, with our primary users, the groups that are recurring renters that have been there time and time again, that we consider our primary users. And the 2 dance companies, help me, Nancy, and 1 orchestra group there were 3 organizations that were really had the interest in extending the time frame out of 6 that we met with. And then, of course, there are all the other individual renters that come ad hoc.
So if one of them had some opportunity, could they come to the board directly and say, we have this exceptional circumstance, and appeal to that? Is there a process for that?
There isn't a written process for that. We can attempt to create one.
I just hate for us to lose an opportunity, whether it's cities or anybody else's, to have something exceptional come to town.
Councilmember DiPolito.
Along those lines, what happens in a situation now if we have somebody who comes in and they have something 4 years out, because our policy now is 6 months, not 24 months. What do we do currently?
They can't book it.
We can't book it.
Not now.
Councilmember Wynn.
I think I agree with both of my council members. I mean, if what I heard from Councilmember Price, if this exceptional group comes in, you know, we're talking 24 months, and I think that we need to look at this. I don't know what kind of language we can put in here, but I just don't think that we should, you know, be very so restricted that if a group does come in and it's a 36 or 48 month out, then we should be able to look at this. I think this is too restrictive, and we need to change the language.
I support the recommendation of the Cultural Arts Board. These folks are doing a good job. They've been given the responsibility for managing this building. I think they have come forth with a responsible way to go from 6 months to 24 months. There's other things under consideration. I have concerns about locking things up 4 or 6 years from now. Give you an example. I've got department head meetings once a month, and I had a council member who wanted to lock up council meeting, you know, a reservation for those for the next year, and I said no. There should be, everybody should take turns, and so I don't know who could come forward next year, and so I hate locking these things up that far in advance. I have reservations, but I'm not an expert on this. And I would go with the recommendation of 24 months at this time and reconsider it in 12 months. Councilmember DiPolito.
I support the Cultural Arts Board as well. However, I would like to suggest that we defer this back to them one more time to see if there's a way to have a special exception. So if somebody comes forward and they have an act or something that they want to present that the Cultural Arts Board feels really would benefit the community, they can go ahead and make that reservation. So maybe we could have it by special exception, be my proposal.
Well, as we discussed in the language which Councilmember Price mentioned, maybe we should have what a special exception is if we're going to create a special exception. So we would have some direction on what special exception meant. Councilmember Eichelhardt.
Thank you, Mr. Mayor. I think it's a good idea to come back one more time to do that, but the mayor and the committee suggested that we have a clause where it kick in, any increase in fee would kick in over that 24 months. I don't think that's probably a good idea for the 24 months, but if we go out beyond that, then it probably is a good idea to say that extra, anything changing would kick in. So as that discussion is held, you know, have those elements be part of that, I would suggest.
Councilmember DiPolito.
As far as the special exception, perhaps we leave it up to the Cultural Arts Board to determine some language, since it is really their field. Would you be comfortable with that?
I am very comfortable with that. Other questions or comments from council? Do we have a motion? Or is this a motion to defer?
Since Mr. Owens is not here, I'll just jump in. I would move to defer this till a month from now. Will that provide a time for the board to meet again?
I believe so, yes, sir.
Okay, for whatever that August meeting is?
Well, then our next meeting, I'm not sure of the dates, first Tuesday in August, so actually it might be after your...
Should it be that last meeting in August then? August the 27th.
Motion to defer to August 27th?
Yes.
By Councilmember Eichelhardt. Is there a second? Second by Councilmember Wynn. All in favor of the motion, raise their hands. Passes unanimously.
Thank you.
We have a report from our city attorney.
Thank you, Mayor. I have a recommendation for closure to discuss personnel and the acquisition of real estate.
Do we have a motion for closure? Motion by Eichelhardt, second by DiPolito. All in favor, raise their hands. Passes unanimously. Ms. Love, I believe we have a work session in room 220 to discuss the Gateway Master Plan.
Yes, sir. Historic Gateway Master
Presentation by DPZ.
Correct.
Interesting stuff coming.